Ladies, my lords, just before the short adjournment, I had dealt with the case of Zalewska. Can I just make one further point about that, which was drawn to my attention very properly by Mr. de la Mare. My Lady Hale asked the question whether one can see from the report that Mr. Lewis, as he then was on behalf of the government, had been putting forward the argument that no proportionality review applies. Yes. There is another passage which makes clear that, yes, he was putting that forward. It's the end of paragraph 53 in my lady's judgment. The great bulk of his argument, that's Mr. Lewis's argument, was addressed not to the proportionality issue, i.e. the issue whether the decision was in fact proportionate, but to whether the rules restricted a community law right at all. That, of course, was the way that the point was being put by Mr. Lewis. He was saying this was not within the material scope of EU law, and that's why the general principle of proportionality didn't apply. To the question that was posed to me by Lord Sales just before the short adjournment, is there any indication of whether a reference was sought? I have not been able to find in the report any indication of whether a reference was sought, but of course the position before the House of Lords in legal terms is the same as the position is before this court, which is both courts are required by Article 267 of the TFEU to refer a question of EU law if it's determinative and not act clair. And now, of course, in Zalewska's case, the question whether proportionality review applied or not was not determinative, because the majority found that that A, proportionality review applied, but B, the decision was in fact proportionate. And so in Zalewska's case, there was no need for the court to refer the question to the ECJ. I've already made the point that, of course, they didn't have Vico Plus either. But
I think my point was more, it doesn't seem as though the government thought that there was any issue, but that proportionality applied. Because they couldn't have assumed what the result of the case was going to be if they thought there was an issue. Yeah. One might have expected that they'd have raised that in advance of the hearing and said there ought to be a reference.
Yes, certainly if the case was within the material scope of EU law, there was no indication that the argument was then put forward that there was an issue as to whether proportionality applied. Of course, that is the argument that I'm putting forward here. And the same position in relation to Article 267 TFEU applies to this court as applies there. Now, can I move then to the final part of my submissions on issue 1, which is to answer the respondent's argument that the availability of proportionality review under EU law doesn't matter because the decision to extend the WRS would be subject to proportionality review anyway under a different rubric, namely Article 14 of the ECHR taken with Article 1 of Protocol 1. Now, it's important to stress that this argument becomes relevant if and only if, as we say, the decision to extend the WRS is compatible with EU law. If so, the starting point for any analysis under Article 14 is that by virtue of the accession treaty, until they have been legally working in a host member state for a continuous period of 12 months, A8 nationals enjoy a special status in EU law, and that status entails a different and lesser bundle of rights than is accorded to nationals of the existing states. Now, against that starting point, I can make my submissions by reference, I hope relatively quickly, by reference to our reply note and paragraphs 11 to 15 of that note. The first point we make, which is in paragraph 13, is that we cite a number of authorities for the proposition that discriminating between persons who enjoy different statuses under EU law does not generally give rise to discrimination contrary to Article 14, even where EU law does not mandate the differential treatment in domestic law. Now, the first authority, I'm not going to go to each one of them. I with the Court's permission, will deal with this point by reference to our note, but I'll give you references so that you have them for your note. The first decision is the decision of the Strasbourg Court in Mustaqim, which is in Authorities Bundle 22, tab 56, MS 2055. And in that case, the Strasbourg Court rejected an Article 14 complaint about the deportation of a third country national. The fact that an EU national could not have been deported in similar circumstances did not give rise to discrimination, contrary to Article 14, because the existence of the special legal order constituted by EU law was itself a reasonable justification, and you can see the passage at paragraphs 49 to 50 set out in paragraph 13.1 of our note.
So what is the nature of the reasoning? Is it that they're not in similar, don't have similar statuses, or that it's going to be proportionate to distinguish?
In Mustaqim, the reasoning, so far as the comparator were other existing or other EU citizens, was that it was proportionate to distinguish. So if you look at the last paragraph, the penultimate paragraph of the indented quote, as for the preferential treatment given to nationals of other member states or communities, there is objective and reasonable justification for it, as Belgium belongs, together with those states, to a special legal order. Whereas as for, it's the previous paragraph of the indented quote, as for the comparison with Belgian nationals, the reasoning was that they were not in a relevantly analogous position because Belgium was not permitted under international law to deport its own nationals. But the second authority, which is referred to at 13.2, which is the judgment of Mr. Justice Blake in the Paviesh case, he adopts the first of these two analyses. Indeed, he says that it's obvious that members of a class, such a class, are the beneficiaries of a special legal regime in a different position from either aliens or generally British citizens who fall outside the scope of EU law. They are thus incapable of being a comparator class. So my Lord asked the question, which of the two, is it non-comparability or is it justification? In fact, what the authorities show is that there is quite a lot of overlap between those two answers or those two ways of analysing the problem. Some of them, the judgment of Mr. Justice Blake, which, as I'll show you in just a moment, is expressly endorsed by this court in the case of New Asley, do it on the basis that the two classes are not comparable. Others do it on the basis that the EU legal order and the different status which is constituted by that EU legal order is itself a justification for the difference in treatment. It doesn't, we say, matter which of the two analyses one adopts. Indeed, I think there's some authority of this court saying that the two analyses can run into each other and that one shouldn't expend great intellectual effort in separating the two of them out.
That's Lord Nichols in Carson.
Yeah, they're both saying, in effect, the same thing.
The basic question is, are they so similar that the difference needs to be justified?
Yeah. And then I'll show you, if I may, the passage in New Asley which affirms or adopts Mr. Justice Blake's analysis. That's in Authorities Bundle 1.3, tab 31, MS 1420. The case of New Asley concerned differences between rules applicable to detention of EU nationals on the one hand and third country nationals on the other. And it's important just to bear in mind here that these are all cases where EU law confers special rights on EU nationals. It doesn't prevent member states from giving those same rights to third country nationals, but it confers special rights on EU nationals. And the question then arises, well, is that difference a difference that offends Article 14, read with some substantive article of the Convention? And the relevant passage is at 1, 2, 4.
142 something.
Yeah, I'm getting our numbers the wrong way round again.
Which paragraph is it, Mr. Chairman?
It is, apologise.
120 is the start of Lord Sharp's judgment.
Yes, it's 45 at page 1432. So at 45 he says, such discrimination is simply a function of the limited scope of the EU legal order. It is not legitimate to draw a comparison between those exercising EU rights and other third country nationals for the purposes of EU discrimination law. Thus, in Baviesh, and the Secretary of State, Mr. Justice Blake, held as follows. Now, one can see from 45, he's talking there about EU discrimination law, but he goes on at 46 to refer to two judgments of the Strasbourg Court in relation to Article 14, Mustakim, and then over the page he refers to another one, Ponomariov and Bulgaria. And what he says essentially is that, well, he makes the point, he draws the distinction drawn just now by my Lord Sales between the two strands of justification, not analogously similar, and difference justified, and he endorses that. Finally, there is the case of HC, otherwise known as Sane, which is in the same bundle at tab 28, and that is the judgment which I made reference to before of my Lord Carnwath. Now, this case was about Zambrano carers, and that's why I made reference to the provision in the domestic regulations which deals with the position of Zambrano carers. And it's relevant because, as here, in Sane, there were two strands to the argument. First, there was an attempt to rely on EU law. So there was an argument run that EU law gave Zambrano carers the same rights in respect of social assistance as EU nationals. That argument failed. Then the argument was made that even if EU law did not supply the relevant right, the discrimination between Zambrano carers and EU nationals, or those with a different immigration status, was nonetheless contrary to Article 14. So the structure of the discrimination argument in this case is similar in our respectful submission to the structure of the argument that we face, that Ms. Mountfield advances here. First of all, we have an EU right. Second, if we don't have an EU right, we have a right not to be discriminated against contrary to Article 14. And that is dealt with at page 1344 to 1345, paragraph 31. At 31, Lord Carnwath says it's unnecessary to enter into the debate about whether Article 8 applies to benefits of this kind, because Article 1 of the first protocol does, or at least he's prepared to proceed on the basis that the case falls within the ambit of Article 14 for these purposes. Then at the bottom of 1344, the status on which Mr. Drabble relies, as I understand his submission, is either immigration status or more narrowly the status of Zambrano carer and child. I do not think that either can assist him under Article 14. Discrimination on the basis of immigration status is, of course, a fundamental and accepted part of both EU and national law, but cannot in itself give rise to an issue under Article 14. Insofar as Mrs. H.C.'s differential treatment arises from her statement as status as a third country national, she can have no complaint. So far as concerns her Zambrano status, that is a creation of European law, and such differences of treatment as there are, as compared to other categories of resident, do no more than reflect the law by which the status is created. Then at 32, there is a sort of, for belt and braces reasons, if one can put it like that, in any event, the test would be without, if there were a proportionality analysis, the test would be manifestly without reasonable foundation, and that test could not be surmounted in the circumstances of the case.
So the reasoning there seems to actually put more emphasis as the primary reasoning on the status point.
Yes, that's right. And we would say it's consistent with the analysis, it's consistent with the Mr. Justice Blake analysis in Baviash, endorsed by this court in New Asley. So finally, we say, and this is the way we apply the principles that you derive from those cases to the facts of this case. At 14, we say, like the third country nationals in New Asley and HC, AH nationals subject to the WRS are not relevantly comparable with the class that includes UK nationals and EU nationals with full free movement rights. The accession treaty gives them a different legal status. As in HC, the differences in treatment reflect the law by which the status is created. As the authorities show, this means that any Article 14 claim would fail either because the comparator is not analogously situated, the approach of Mr. Justice Blake, endorsed in New Asley, or because the preferential treatment given to EU nationals under the EU legal order itself constitutes an objective and reasonable justification for the differential treatment, as the Strasbourg court put it in Mr. Key. But they both come to the same thing. Finally, and this is paragraph 15 of our note, we make the point that if a proportionality analysis did fall to be conducted, it would be a very different proportionality analysis from the one undertaken here. First of all, the thing being justified, the protected interest, if you like, to pick up the terminology that I referred to earlier, would be not the intrusion into free movement rights or interests, but the differential treatment, the discrimination, if you like, between two statuses, existing member state nationals on the one hand and A8 nationals on the other, that are expressly distinguished by treaty provisions. The analysis would be confined to the question whether that differential treatment was manifestly without reasonable foundation. See paragraph 33 of Lord Carnworth's speech in HC. And in answering that question, the fact that the discrimination was envisaged and permitted by EU law and of short duration would be highly relevant. If we are right on issue 1, then issue 2 does not arise. If the answer on issue 1 is not act clair, and the point is determinative of the appeal, then of course the obligation in Article 267 of the treaty kicks in. And I turn then to issue 2, which is our challenge to the proportionality assessment. As I've said, this issue arises if, contrary to our submission, proportionality review is required under EU law. We say that the upper tribunal and the Court of Appeal erred in finding the decision to extend the scheme was disproportionate. So before I make my submission, which I hope I can do relatively briefly, can I just explain what the background was before the Secretary of State in 2009 when considering whether to extend the scheme? The scheme had been introduced in 2004. GDP growth in the previous year had been 3.3%, and there were at that stage no concerns about numbers of A8 nationals. The reasons for introducing the scheme were in large part concerned with collecting data.
Yes.
The House of Lords in Zalewska had by majority held that the re-registration requirement was proportionate. But, I'm not going to go to it, but I give you the reference at this stage. See Lord Hope's speech at 36, Authorities Bundle 13 tab 33, MS 1531. It was common ground in that case that the initial registration requirement was proportionate. At least it wasn't challenged. By 2009, of course, the financial crash had occurred. GDP growth in the previous year was already negative, and the position was deteriorating. Under the treaty, there were essentially two options: either maintain the existing measures or relax them. The government therefore asked the Migration Advisory Committee to consider the likely labour market impact of relaxing the measures and whether it would be sensible to do so. The committee concluded that the UK labour market was seriously disturbed, and the respondent has not suggested that any other conclusion was realistically open to it. Now, the committee did not pretend that relaxing the measures would substantially reduce A8 inflows. It did, however, conclude that relaxing the measures would probably increase those inflows by a small amount, thus exacerbating an already bad situation. It also concluded that it would reduce the stock of data available to the government for monitoring labour market conditions. Overall, its conclusion was that maintaining the scheme would, in small measure, probably help to address the serious labour market disturbance it had identified. Now, as I've said, most successful proportionality challenges succeed by showing that there are less restrictive or intrusive means of achieving the benefit sought. In this respect, the reasoning of Upper Tribunal Judge Ward is unusual because there was no finding that the small benefit identified by the MAC could have been delivered by any lesser measure. Rather, there were two findings. One can just pick those up at MS 272. The first finding is at paragraph 112, and that is that the maintenance of the scheme is not an appropriate tool for proportionality purposes for addressing the serious labour market disturbance identified. And the second finding, which you see between 114 and 118, is a finding of what, as I've said, is often called disproportionality stricto sensu. And that is the finding at 117 that the small and speculative advantage is wholly outweighed by the disadvantage of A8 nationals and employers and the limitation on treaty principles of free movement. Now, I've already made the point in relation to that last issue, and I'm going to come back, that there is Judge Ward doing precisely what the Court of Justice in Vico Plus has said should not be done. But can I deal first with the first finding, the finding at 112? That finding is based on the following reasoning, that the fee of £90 is the only dissuasive element of the scheme in terms of dissuading people from coming from A8 accession states to the UK, and the fee is not an appropriate tool for addressing a serious labour market disturbance. As to that, we make 3 points. First, it's well established in EU law that member states have a discretion as to the level of protection they wish to achieve by measures subject to proportionality review. And if authority for that proposition is needed, it's paragraph 64 of Lumsden, which is, you have in, I'm not going to ask you to turn it up, but in Authorities Bundle 13, tab 29, MS 1382. Now, many member states chose to achieve a high degree of labour market protection in 2004 with a correspondingly higher impact on A8 nationals, because many of them decided to exclude those nationals altogether from their labour market. Others, like the UK, chose a lower degree of protection for the domestic labour market with a correspondingly lower impact on A8 nationals because they were admitted, provided they were registered. Second, by 2009, no one was claiming that the measure would have more than a small effect on inflows and data. The question of suitability or appropriateness had to be answered against that background. Was the extension of the scheme appropriate to achieve the admittedly small benefit that it was understood it would achieve? And third, the MAC report, we say, provides a proper evidential basis for concluding that the retention of the scheme would probably provide that admittedly small benefit. See in particular paragraphs 3.16 to 3.17 on MS 307. As to the finding of disproportionality stricto sensu, that's the finding at 114 to 118, again we make 3 points. First, we know from Vico Plus that the question whether a transitional measure is proportionate in the light of the treaty principles of freedom of movement does not arise. But paragraph 117 indicates that this is exactly the analysis that Judge Ward undertook. The small and speculative advantage, he said, was outweighed by the disadvantage to A8 nationals and employers and the limitation on treaty principles of free movement. Whatever else falls to be taken into account in striking the proportionality balance, the limitation on treaty principles of free movement does not. That in and of itself indicates what we would say is a fundamental error in Judge Ward's approach or analysis. Second, the analysis here is conditioned by the judge's finding at 98 in his judgment on MS 269 that the present matter did not involve political choice to a significant degree. We say that was wrong. The fact that a decision is informed by an expert recommendation does not mean that the decision was anything other than a macro-political one. Nor does the fact that the decision was not objected to in Parliament. A decision not to extend the scheme, in the light of advice that that would exacerbate an already dire situation, might well have generated an objection. We don't know. Third, the finding at 118 that the measures would fail the proportionality test even if a manifestly inappropriate standard applied is based on the same reasons, which impermissibly include the limitation on A8 nationals' treaty rights, which the Court of Justice has said does not fall to be taken into account. If, as we say, the manifestly inappropriate standard is the correct one for a macroeconomic or macro-political decision implementing an EU treaty provision, that standard is not met in the light of the committee's findings. Ladies, Lords, I don't have very long left to deal with issues 3 and 4, but I think, need a great deal of time to deal with those issues, and I hope I can do so mostly by reference to my case. We deal with issues 3 and 4 beginning at paragraph 45 of our case on MS 137. Now, I've already made the obvious textual point that Article 16 is the main provision of Chapter 4, which deals with the right of permanent residence. It contains the general rule from which Article 17 derogates. and it unambiguously provides that it is union citizens who have resided legally for a continuous period of 5 years in the host member state who have the right of permanent residence, not subject to the conditions in Chapter 3. Everyone accepts that for the purposes of this general rule, to reside legally, you have to reside in accordance with the provisions of the directive, and in particular, Article 7. I've also made the point already that the right of permanent residence is an important and valuable one for two reasons. The first is it's not subject to qualification or condition. You have unqualified access to the host member state's social assistance system. And the second is that you can't be expelled from the host member state other than on serious grounds of public policy or public security because of Article 28.2. Now, Article 17, as I've said, contains an exemption from the general rule for persons no longer working in the host member state. But the opening words are a clear reference back to Article 16. By way of derogation from Article 16, the right of permanent residence in the host member state shall be enjoyed before completion of a continuous period of 5 years. Well, it doesn't say a continuous period of 5 years of legal residence, but it must mean that because it is a reference back to Article 16, which says so. Now, on the respondent's case, the effect of the omission of the word legal from the subparagraphs A to C is that while a person who comes to the UK to work has to reside legally for a continuous period of 5 years before attaining a right of permanent residence, a person who retires in the host member state can attain the right of permanent residence after 3 years' residence, even if that residence is not in accordance with the provisions of the directive. We say that that is both incoherent and contrary to authority. So far as coherence is concerned, it seems to involve the contention that the omission of the word legal from the opening words of 17.1a was an understandable contraction of Article 16.1, whereas the omission from the subparagraphs that follow it connote an intention to achieve a fundamentally different effect. That is implausible. It also involves the proposition that a working-age A8 national must work legally for 5 years to acquire a right of permanent residence, whereas an A8 national who comes here 3 years before retirement age can acquire the same status even if, for the whole of the first 2 years, he or she is residing unlawfully. And we say there is no sensible policy reason why that anomaly should have been intended. So far as authority is concerned, we set them out in our case. I'm not going to go through them all. There is LaSalle, there is Diaz, there is Jolkowski, and there is Alarape. Finally, there is Vomero. But what all of these authorities do is they make the point that the right of permanent residence is a very valuable one, and that the conditions under which one acquires that right of permanent residence must be strictly construed. And we say that those authorities, for the reasons we've given in our case, are inconsistent with the proposition that one can somehow acquire a right of permanent residence without having resided in accordance with the provisions of the directive. Now, the main argument against us on this is based on the provisions of the predecessor instrument, Regulation 1251 of 70. And the argument is that that instrument conferred a right of permanent residence equivalent to that in Article 17.1a on those who at the time of retirement had resided in the host member state for 3 years, provided they'd worked for the 12 months prior to retirement. And the argument is, well, that right applied irrespective of the legality or otherwise of the residence. Our answer is that there never was any such right. There is no case establishing it. None is referred to by Judge Ward or by the respondent. It would be very surprising indeed if Regulation 1251 of 70 had indeed conferred that right of residence, because 1251 of 70 was enacted at a time before the Maastricht Treaty, when there was no treaty article conferring any right of citizenship at all. At that time, a person who moved to reside in another member state but couldn't show that she had done so in exercise of a free movement right wasn't protected by EC law at all. And that's established by the old case of State and Watson, which you have in Authorities Bundle 2.1, tab 49, MS 1794. Finally, when the Citizens' Directive was adopted, the understanding was that it was simply consolidating the existing legislation on free movement, save that it was giving something extra. It wasn't taking away rights, it was giving something extra, namely the right of permanent residence. And that can be seen from the preamble to the instrument that repealed Regulation 1251 of 70. And you have that in Authorities Bundle 1.1, tab 2 at MS 537. Now, I see the time.
Yes, so do I.
Can I just say this in relation, probably 2 or 3 sentences in relation to issue 4? It's a very straightforward issue because issue 4 arises on the assumption that we've succeeded under issue 3 in showing that what's required by the directive is legal residence. And we've set out in our case why under issue 4 we say the domestic implementing regulations ought to be given the same construction as the directive. Essentially, the reasons are these. We rely on Lord Mance's judgment in the Energy Solutions case at 39, that's Authorities Bundle 1.3, tab 27, MS 1324. It is a natural assumption that the UK legislator will not go further than required by EU law without considering this and making it clear. We refer to at 83 of our case, we refer to the transposition guide issued by the Cabinet Office, stating that it was government policy at the time not to go beyond the minimum requirements of any EU directive unless there were exceptional circumstances justified by a cost-benefit analysis and extensive consultation with stakeholders. And at 84, we've set out the material which accompanied the domestic regulations, and there is nothing in that material which indicates any intention at all to gold plate the directive. So the conclusion that we invite the court to draw is that the domestic implementing regulations should be given precisely the same reading as the directive is given, and for that reason we respectfully submit that they also should be read as requiring legal residence, that is to say, residence in accordance with the directive. For these reasons, my ladies, my lords, we invite the court to allow the appeal on issue 1, or alternatively on issue 2, and we invite the court to dismiss the respondent's cross-appeal on issues 3 and 4. We draw the court's attention to its obligation under Article 267 of the TFEU to refer to the Court of Justice any question of EU law which is both determinative of the appeal and also not act clair.
Thank you, Mr. Chamberlain. You are docked 3 minutes from your reply time.
Noted.
Yes. Mr. Blundell.
Thanks, Father, my lady.
Ms. Mountfield.
Ladies and my lords, in 2003, after consulting the Commission and the EU Parliament, the Council of the EU decided to expand the EU and to take in 10 more members. And 2 of them, Cyprus and Malta, were so small as to be effectively regarded as de minimis, but the other 8 accession states were larger and had workforces who, on the whole, were paid less than nationals of the existing EU member states. And it's important to recognise, therefore, what the existing EU states were doing. They had decided to extend EU citizenship rights to the A8 nationals. And the fundamental rights of citizenship, which flowed from that status of citizenship, which were then contained in a number of legal instruments which preceded the Citizens Directive, were also extended to those nationals. But recognising that a sudden and unchecked wave of new migrants and unchecked access to the single market for economies which did not conform to the same standards, for example, in relation to harmonised tax regimes, which is the issue in the Valeska case, they recognised that might destabilise the economies of the existing member states. And so, on a transitional basis, the Treaty of the Accession and the Act of Accession, which gave effect to the Council decision to expand, conferred on member states various discretions as to the speed at which and the conditions upon which they would allow nationals and businesses from the new accession states to have immediate and unchecked access to their markets. And that was usefully explained by Lord Justice Elias in a case which we don't actually have in the bundles. I'll get it for tomorrow, but it's referred to in the decision of Upper Tribunal Judge Ward. Perhaps I can ask you to look it up now. It's in the core volume, MS 261. Upper Tribunal Judge Ward referred to it in paragraph 70 of his judgment. So at the bottom of 261, having referred to the exceptions, which I'll come to free movement rights conferred by Annex 8, he said that such provisions serve to offer a degree of protection to the labour markets of existing member states if a state chooses to avail itself of them. However, the starting point under the accession treaty is that A8 nationals have the full rights of free movement conferred unless a state chooses to limit them. So it's an important starting point that the Act and Treaty of Accession did not oust free movement rights for the accession state nationals, but what they did do was provide that it could be and might be acceptable for greater limits to be imposed on their free movement rights than those which applied in general for a transitional period. Now, the occasion of this appeal, as you know, is a determination of whether the respondent is eligible for a state pension credit. And she is eligible for that state pension credit if she is a worker who has worked for it over 12 months before her retirement, has reached retirement age, and who has ceased activity. And it's common ground that she is such a person in accordance with Regulation 5.2 of the 2006 regulations, page 641. The issue is whether, as a matter of law, she should also be treated as having the requisite 3 years of residence immediately before retirement. And the appellant says not. Her residence, which was from 2009, should not be treated as residence for those purposes because, he says, such residence has to be in exercise of an EU law right to reside, relevantly as a person who's been admitted to the labour market as a worker. And because Ms. Gubeladze was only admitted to the labour market as a worker from August 2010, when she signed or became a registered worker, she, on the Secretary of State's case, falls outside that definition. We say that both the Upper Tribunal and the Court of Appeal were right to say that her residence should have been treated as being in exercise of an EU law right to reside. Because we say the factor which excluded her from that definition of the worker, the failure to sign the register after November 2009, was a disproportionate infringement of her free movement rights, bearing in mind the power that there was at that stage to extend the workers' registration scheme. And it flows from that fact that the fact that she hadn't signed the register should not be held against her, and so all her work from November 2009 should have been treated as being in exercise of EU free movement rights. And then issues 3 and 4, we say that in any event, she did not need residence as a worker, residence simpliciter was enough. Now, on the first point, the appellant says that the reason the upper tribunal and the Court of Appeal erred is because they should not have looked at the issue of proportionality at all if, as we accept, the condition precedent for that second extension decision, its serious disturbance of the labour market, was made out. If those courts did look at the question, they should have held the extension decision proportionate, and the residence did have to be an exercise of an EU law right, and she has to succeed on all 3 of those points to succeed on this appeal. So what this case is about is whether there are legal controls on the exercise of that EU law discretion by a member state at this stage of transition and the proper ambit of that discretion. So I start with issue 1. Mr. Chamberlain properly accepted that the decision as to whether to extend the workers' registration scheme was susceptible to judicial review, in answer to a question from my Lord Carnworth. It follows, therefore, that the general principles of EU law judicial review apply, and the extension decision is subject to judicial scrutiny to decide if it was a lawful exercise of the EU law power to extend the workers' registration scheme. And that question includes the question of whether it was a lawful exercise of the power to continue the derogation from free movement law. Now, the power to extend the transitional limitation was conferred by an EU law instrument, the Act of Accession, which expressly says that existing EU principles of law and the decisions of EU law institutions apply in respect of the treaty. So we say that the House of Lords was correct in Zalewska to hold that the UK's power to decide whether and to what extent to set conditions on the access of AA nationals to the labour market was circumscribed by the terms of the treaty and the Act of Accession. And that being so, it was subject to normal EU standards of proportionality and review by national courts. And we say that Mr. Chamberlain's new submissions on Vika Plus and Walewska are not authority to the contrary when you read them against the clear language of the treaty and Act of Accession. What they say is that the proportionality exercise is to question whether the exercise of this power of derogation from general free movement rights is proportionate in the circumstances, not would this be a proportionate infringement of free movement rights in general if these transitional provisions did not exist. They channel the proportionality exercise through the instrument that's being exercised, which is the Act of Accession, not wider provisions of EU law, but they don't exclude the proportionality exercise, and that's not what the Court of Justice was saying in those cases. The second point is that the discretion which the UK enjoyed in deciding whether to extend the workers' registration scheme was limited in law to the purpose for which that power of second extension was granted. And that was, we say, to respond to a disruption, a serious disruption in the labour market. So it had to be a response to it, in effect the European Padfield point that Mr. de la Mare makes, and it had to be a proportionate response. The power could only be exercised for the purpose for which it was conferred by the Act of Accession. And there's consistent case law, which is that those powers were granted to address the actual or potential serious effects of disruption to the labour market. Can I just show you the 2 references to that now? The first is the Profeta case, which is in the additional bundle of authorities. It's MS 2747. paragraph 41, where the court said that the transitional provisions in the Act of Accession are intended to prevent, following the accession to the EU of new member states, disturbances in the labour market of the existing member states due to the immediate arrival of large numbers of workers who are nationals of those new states. And it cites to that effect Vico Plus, which again refers back to other authorities to that effect. Vico Plus, paragraph 34, for your note, is at volume 1, 2, tab 22, MS 1183. And we say that the decision to repurpose the workers' registration scheme, which, as Mr. Lewis submitted in the Zalewska case, was intended purely as a monitoring measure and not as a restriction on numbers, repurposing that as a measure which potentially might have some effect, some slight effect, as a measure to keep limited numbers of A8 nationals out of the labour market, was not rationally linked to the serious disruption of the labour market, which admittedly existed in 2009, but was caused by the financial crisis. The Secretary of State had no evidence to suggest that it was rationally linked or to justify limiting the enjoyment of social and economic rights of people who would come from those A8 states after 2009, arising from their work in order to, as a result of extending the scheme. And then we say that even if we needed to find some different route to a disproportionality analysis, we would get that through Article 1 of the First Protocol and Article 14. So the first issue is whether proportionality review is engaged as a matter of EU law. And the suggestion that it was not, provided that the condition precedent for a second extension of the scheme arose, is intrinsically unlikely in my submission within the legal order of the EU, because proportionality is a fundamental aspect of the legality of any measure within the EU legal order. It is always a question for the court, this is common ground, whether there is a rational link between the adoption of a measure and the purpose for which the power it's said, which is said to permit the measure, was given, and that is one aspect of the proportionality exercise. And as a matter of EU law principle, this is my second point, the Act of Accession has to be construed purposively, and the powers conferred by it must be exercised proportionately to their interference with the EU law rights of EU law nationals, which are themselves conferred by EU law, although subject to limits. Mr. Chamberlain's argument to the contrary has to proceed on the basis that the Act of Accession in effect ousted any relevant EU law rights of the A8 nationals for so long as the transitional provisions were in place. And that is simply wrong, once one appreciates that the purpose of the Act was to bring within EU citizenship the nationals of those countries, subject to particular time and context limited constraints on the rights which were so granted. And because of that, it is wrong to say that there are no relevant rights or interests upon which a proportionality analysis can bite. Rather, this is the important point that arises from Vico Plus, the proportionality analysis is a question of the proportionality of the exercise of the derogation power in that instrument, and not a derogation from the general principles of EU law. Now, to make good my submission that the Secretary of State is wrong in suggesting that the Act of Accession ousts all generally applicable EU law principles in relation to free movement of workers while the transitional provisions are in place, I need to go to the language of the Act of Accession and the treaty. Although Mr. Chamberlain's taken me to them, I'd like to just highlight slightly different aspects of them. So if I could turn that up. It's in the first volume of Authorities, tab 4, MS 563. So 563 is the decision of the Council, to which I referred, to accept applications for admission. The adjustments to the treaty entailed by that to be the subject of agreement between the states and the various accession states. And then at 565, the start of the treaty, page 570, I'm so sorry. Mr. Chamberlain took you to Articles 1, 1 and 2. But it is important to note in Article 1 and 1, 2 that Article 1, 3, that the provisions concerning the rights and obligations of the member states and the powers and jurisdiction of the institutions of the Union as set out in the treaties referred to in paragraph 1, and that's the original treaties, shall apply in respect of this treaty. So the Treaty of Accession isn't some piece of sui generis international law. It is part of the EU national order, and it's governed by its principles and its institutions. And the member states must abide by the power and jurisdiction of the institutions of the Union as regards its operations. So the principles of EU law, as set out by the Court of Justice, which is an EU institution, apply to the application and interpretation of this treaty. The Act of Accession itself starts at page 580. That's where you get the definition of the original treaties in Article 1. And at the bottom of the first column on page 580, the institutions, meaning the main EU institutions. Then Article 2 provides that from the date of accession, the new member states must also abide by the treaties. And then Article 10, on page 583, providing that the application of the original treaties and acts adopted by the institutions shall, as a transitional measure, be subject to the derogations provided for in this Act. Again, the existence and the extent of the derogations is a matter of EU law to be interpreted by the EU institutions. Article 24, Mr. Chamberlain showed you, making reference to the annexes for different states, page 587. I'm not sure whether he took you to page 592 and Article 37. But there was provision in Article 37 for the first 3 years, if a member state had not chosen to derogate from free movement rights, but difficulties then arose, which were serious and liable to persist in a sector, then such a member state could request the Commission by emergency procedure to determine various protective measures. So the free movement rights arose. There was a procedure for limiting them further in particular circumstances beyond that which was set out in the annexes, which were set out for individual states, although only in the first 3 years. Then we go to Annex 8 on page 597, and the language of Article 1, the free movement provisions shall fully apply only subject to the transitional provisions laid down in paragraphs 2 to 14. Again, I say that supports my case. They do apply, but they are subject to whatever measures are taken under the other articles of this annex. The articles provide that there shall be such derogations in effect as the member states want, in national bilateral agreements for the first 2 years, only applying to new accession state nationals working for the first, sorry, I'll put this another way, the accession state nationals working in the host state for the first time, i.e. those who were not working legally before the accession, and only for the first 12 months of that work. Then paragraph 3, the power for a member state, an existing member state, to extend whatever limitations they had decided upon as a result of bilateral agreements for another 3 years. But that is not an absolute discretion to extend, because it provides that before the end of the 2-year period, from the beginning of the accession, the Council shall review the functioning of the transitional provisions laid down in paragraph 2, and then on completion of the review, and by a particular date, Member States will notify the Commission whether they will continue to apply the national measures. And Mr. Chamberlain accepted that this decision, exercises of discretion by states under this provision, would be susceptible to judicial review. But it must be the case that a member state exercising that discretion in Article 3 would have had to consider what the Council had to say. And if the Council had said, we note that notwithstanding the expansion of the EU, there are major labour shortages in all the states of the pre-existing EU nations, it would be surprising if it had then been a proportionate measure for the member state to say we still intend to keep our limitations of Article 1 to 6 of Regulation 1612 of 68. So that really illustrates that the discretion was not a complete discretion at the will or whim of the member state. There were factors which, as a matter of implication, the member state would have to take into account. But nonetheless, it is a broad discretion on the member state, taking into account all matters which appear relevant to it, to decide whether to extend the transitional limitations on free movement rights for that second 3-year period. But then, in Article 5, the member states may the member state may, in case of serious disturbances, and after notifying the Commission, continue to apply those measures until the end of a 7-year period. That only arises in case of serious disturbances of the labour market. And the government suggests that that means that so long as there was a serious disturbance of the labour market, it was really a matter for the member state, with no further supervision by any court, to decide if that, to decide whether it wished to extend. And the court can't supervise that by reference to proportionality analysis at all. But that analysis is wrong, because it proceeds on the basis that there were no protected interests existing while Article 1 to 6 of 1612 of 68 were limited by the transitional provisions. And we've shown that that's wrong, because there were those interests subject only to their decision, the exercise of discretion as to whether to limit those rights. And the power to impose any transitional limitations at all was granted for the reasons which I showed you, set out in Profeta and Vico Plus, to ensure that, or to tackle potential disruption to the labour market due to the influx of people from member states. If the power was used for some other reason, it was used unlawfully as a matter of EU law, even absent proportionality analysis.
Can you help me
Yes.
point? On the continuation of the measures,
Yes.
do they have to be the same measures that are continued? I mean,
Continuation measures do. That raises the point that Mr. Chamberlain made. He drew your attention to paragraph 6 of Annex 4 that says, during the 7-year period following the date of accession, those member states in which Articles 1 to 6 of Regulation 1612 of 68 apply, it's paragraph 7. Paragraph 7, that those member states in which Articles 1 to 6 of 1612 of 68 apply may resort to procedures set out in subparagraphs below, and those are the procedures that where the member state undergoes or foresees disturbances in its labour market, it can request the Commission to state that the application of those provisions is wholly or partly suspended. Mr. Chamberlain said that doesn't apply to the United Kingdom because if it has measures, if Articles 1 to 6 of 1612 of 68 have been suspended by the extension of the measures that were adopted at first instance, then it doesn't have the power to go to the Commission and say, can we do something different because we have a serious disturbance in our labour market or we anticipate a serious disturbance in our labour market. I think it's right to say, or I submit it's right to say, that you couldn't at one and the same time extend the measures which you had at first instance and say to the Commission, can we do something else? Because if you're extending the measures at first instance, you would thereby have limited or ousted 1612, the first 6 paragraphs of 1612 of 68 and said those don't apply, our bilateral treaty arrangements apply. But that's not to say that the Secretary of State could not have said, we've looked at the MAC report, the workers' registration scheme was never intended to keep out workers, it was intended to monitor and give us information about what we needed to know. We've looked at that and here is some different provision which we consider would help us with a disturbance to our labour market. We want to limit these workers to particular areas or sectors, or we want to have a permit system. So it's not to say that it was a purely bilateral choice for the United Kingdom in 2009. Either you extend the workers' registration scheme, however irrelevant it may be, or you do nothing at all. But, sorry, binary. I used the wrong word. Binary choice. Now,
well, I suppose you're suggesting that if the United Kingdom was really seriously concerned about the influx of A8 nationals, yes, it could have said to the Commission, well, of course, we could extend our existing measures, but that's not going to help us very much because they're not designed to keep anybody out.
Yes.
They're just designed to let us count the people who come.
Yes.
That's certainly the view that we took in Zalewska, and I believe it
yes,
to be correct on that point.
Well,
but instead of that, we want to do something more drastic.
Or something different and more effective.
Something different,
yes,
something that actually did keep some
yes,
people out, which we could have done from the outset had we chosen so to do, but
yes,
we didn't. So they can go under Article 7 to the Commission and say, please let us do that.
Yes.
They can't do it as of right, they'd have to ask.
They would have to ask.
But does Article 7 cover that situation?
Yes.
That's what I'm trying to understand.
Yes, it does.
Yes, my submission is that it does.
If you
yes,
don't extend, it does, because by then, Articles 1 to 6 do apply.
Yes. And there's, yes, Malengin points out to me at the top of page 598, a member state could, in an urgent case, decide what it was going to do and then go to the Commission and say, that's what we've done.
That's an urgent and exceptional case.
Yes.
That's not what you're talking about now. You're talking about being able to do it under the main body of Article
Yes.
7. Is that right?
Yeah, well, I'm just drawing attention to the fact that...
But I just want to be
yes,
clear how this works. I'm not...
Yes.
I mean, as I understand, if one starts from 2, the initial decision is to apply national measures.
You decide.
And in this country, we decided simply to
yes,
have a registration system. Then there's a question of extending that for the 5 years, and that has to be the same measures.
That's an extension of the same measures, but you have to look at what the Council says about how those have operated and consider, do you want to do it? It's not...
Yes, no, I understand that, but it's a question of doing more.
Yeah.
That's what I'm trying to understand. You say that when it gets to 7, it can, rather than just extending the measures it's got, it can go to the Commission and say, well, we want some bigger and better measures.
Or different measures.
Yeah,
I mean,
and it can do that not only in the urgent and exceptional situation covered by the last paragraph, but can do it more generally.
Yes.
Is that right?
Yes.
I don't know whether that's common ground, but I'll be interested.
And my lord, the reason I say...
Sorry, could I just say,
Yes, of course.
I think I'm right in saying that Mr. Chamberlain said there was a binary choice in paragraph 3, that either you continue with the measures you've already got, or you just don't, you go back to articles 1 to 6.
I may have misunderstood. I thought he was saying that the binary choice was at paragraph 5 as well.
I see.
And that's what I'm saying, that the binary choice isn't only at a binary... At the point where you say we now have a case of serious disturbance of our labour market, or we anticipate one, it isn't, well, we better keep going with what we've done or just open the doors. There is another power to say what would be a sensible and proportionate thing to do here, and it may be something different, it may be something less or greater or just different and more effective.
But the prior question relates to the meaning of the words continue to apply these measures in Article 5. If these measures mean the ones we've been doing so far, then it's a binary choice. But if it means these measures, national measures or bilateral measures, in a more general sense, it may be a wider choice.
That's really what I'm driving at. I think perhaps the point arises both on paragraph 3 and paragraph 5, but it doesn't say it shall continue applying the national measures. It just says national measures. Yeah. I may have got the wrong end of the stick, but I thought Mr. Chamberlain was saying you had to continue, you had a choice. You continue at the same level in terms of national measures, subject to, I think he referred this to paragraph 12. So what I'm really just wondering, if you had, let's say, 2 lots of measures from the start, both of which have some restrictive effect, I would have thought, looking at paragraph 3, that at the extension point you could choose to drop one of those and just continue with the second. You're not forced to have the whole gamut or nothing at all.
My lord, either through the route you suggest or through paragraph 7, the submission I'm making is that it's wrong to say that there's no point in a proportionality analysis because the Secretary of State could either open the floodgates or do nothing at all and keep with what they've got. There was a broader choice as to what measures might be appropriate and suitable if that situation arose. So the first limb, the important basis upon which the Secretary of State's submission that proportionality analysis is inapposite arises is that there are no relevant issues which are being limited. And it's only if there's a limitation on a relevant EU interest or right that the Court of Justice would expect this court to look at the proportionality of the measure. What he says in paragraph 34.2 of his written case at page 133 is that the purpose of the Act of Accession is to ensure that relevant interests do not arise. Free movement rights do not arise and so do not constitute protected interests during the transitional period. And that's wrong because the Act of Accession doesn't oust free movement rights. It confers a power to oust rights under Articles 1 to 6 of Regulation 1612 to 68 in various situations and to various extents. And that's also borne out by...
I'm still struggling with this. I'm being very slow. There's a binary choice under Rule 3 or Rule 5, subject to Lord Sale's point, you might have 2 options. But if you only got one form of restriction, then you either have to maintain that or you have to drop it, right? Unless you move, or reduce it, yes. Unless you go to Article 7, which entitles you to say to the Commission, well, we want to spend the whole lot, including Article 1. And that's obviously a much more drastic measure, but you have to justify it to the Commission. So at that stage, you can either decide to continue the measure you've got, you can get rid of the measure you've got or reduce it, or your only alternative is to go to the Commission under second part of Article 7 and say, please suspend the whole thing. Thank you.
And the fact, my lord, that the Act of Accession doesn't oust all free movement rights is affirmed in my submission by the decision of the House of Lords in Zalewska, or the way that the House of Lords analysed the question in Zalewska. That's in volume 1.3, tab 33, starts at MS 1516. At 1517, sorry, 1519, paragraph 4, Lord Hope said the starting point was the EC Treaty. Article 18 sets out one of the rights of the citizenship of the Union, the right to move and reside freely within the territory of member states, and then Article 39. So the starting point is EU law in general. And then at paragraph 27, MS 1526, at the bottom, looking at the limitations on rights under 1612 of 68, those are the rights to either hire or be hired as a worker. It says it's true that paragraph 2, that's of Annex 8, does not mention Article 7 of Council Regulation 1612 of 68, but there are two reasons for this. Over the page 2613 on the internal numbering, access to labour markets is treated as a question of eligibility. The fundamental rules about eligibility are set out in Articles 1 to 6. A national of a member state who takes up employment in another member state is a worker for the purposes of Article 7, but not otherwise. And then just below letter C, that the exclusion from derogation ensures that any workers from Poland who did obtain access to the labour market in an existing member state under its national measures enjoyed the same guarantees against discrimination as regards conditions of employment and social and tax advantages as national workers, but they were to depend on their compliance with national measures. So these are limitations on EU rights, not ousters of them. And if a member state decides to let people into its labour market for whatever reason, then they have the same rights still on discrimination. You can't say we'll let in Latvian or Polish workers, but only if they work for less, or only if they don't join trade unions, or only if they don't get the same tax and social advantages arising from it. And while we're on Zalewska, page 1528 is the proposition that once one accepts one is within the scope of EU law, which was the submission made by the Council for the Secretary of State in Zalewska and disavowed by Mr. Chamberlain here, then the idea that the national measures that the UK selects, assuming they do have something to do with national law, then the issue is whether they are proportionate. And the reason is at the bottom of page 1528, national measures that the member states introduce under the authority of the Act of Accession must be compatible with the authority given and with the community law principle of proportionality. Proportionate to what? Proportionate to the decision to derogate from the rights of citizenship and free movement, which would otherwise have been conferred on A8 nationals by the Act of Accession. And
So you're saying that what goes in the balance is the right of freedom of movement, which otherwise would have been given.
Yes, but what goes in the balance is not, one doesn't get to the question that you'd otherwise get to of a proportionality analysis if one were to say, let's let in French workers and not German workers or something like that, because it's recognised by the Act of Accession that there may be reasons, special reasons, for limiting particular rights that should otherwise be general rights for this specific group.
Yes.
And the question is, what is the proportionality of deciding to derogate from the rights of citizenship and nationality which would otherwise be conferred for the transitional period for this specific group? But you do have to bear in mind that it does engage protected interests. That once the accession has happened, accession state nationals do have protected interests, and the question is the proportionality of the measures which limit them under that Act of Accession and the transitional provisions there. So once one appreciates that the Treaty of Accession and the Act of Accession do not extinguish the interests that arise from EU citizenship, but simply confer powers on states to derogate from them in special circumstances that wouldn't apply to a general derogation from those rights, then there is no convincing reason to depart from the authority of Zalewska on this point. And of course, the practice statement says that you'll generally follow the authority of a predecessor to this decision of this House or another one, unless there are good reasons to depart from it.
Can I just check? Did all the nationals of the AA states become EU citizens for the purposes of the treaty as soon as they acceded, the states acceded?
Well, my Lord, yes, my submission is they did, because of the Articles 1 and 2 that says that
there's accession to the relevant treaty. I forget which one it is now. Is it TFEU at that stage?
Yes, I think
and
it's...
so they simply are nationals of a member state at that point.
Yes.
And therefore are EU citizens by virtue of that nationality.
Yes.
Right, thank you. I just wanted to check I understood.
Is that clear?
Yes, my Lord, page 570 in Authorities 1.1, this is the Treaty of Accession. Article 1.1, the accession states become members and parties to the treaties on which the Union is founded.
Will you read it from, please?
Sorry,
sorry,
1.1. Yes, page 570. So this is within this tab there is the Treaty of Accession. Well, first there are the Council agreement to have a treaty, then there's the treaty, and then there's the Act, which is part of the treaty. So this is the treaty, and Article 1 says the accession states hereby become members of the EU and parties to the treaties on which the Union is founded, as amended or supplemented. The treaties upon which the Union is founded say that a national of a member of a state of the EU is a citizen, and citizenship is their fundamental status. That's what Lord Hope said was the starting point in paragraph 4 of Zalewska. And then the conditions of admission and adjustments are set out in the Act of Accession.
Well, the citizenship thing is in Article 17, isn't it?
Yes, it was Article 17
of the old treaty.
Yes.
So it was there at accession.
Yes,
that's
it was.
The point.
Yes,
yeah.
so there was a right of citizenship at the point of accession. So when the states became states, the rights and obligations that they became members of the treaties, and the treaties said citizens of those states shall be nationals, subject to the provisions in the Act of Accession. The Act of Accession says that Article 39 rights apply only insofar as the transitional provisions say they apply, but it doesn't say, but you're not a citizen until the end of the transitional period. And the authority that we cite, a very old authority for the general proposition, I don't really need authority for the proposition that proportionality is a principle of EU law, but it's the Einfuhr case. It's at tab 9 of the authorities bundle. Can I just ask you to note, I'm not sure we need to turn it up, but it's paragraphs 12 to 14, MS 1753 to 1754. When one is looking at the proportionality of a measure which limits fundamental EU freedoms, the question is not just to the principle of whether a member state is going to limit one of those freedoms at all, but the practical elements of the limitation. We see that all the time. You can have a workers' registration scheme. The question is whether the elements of the scheme are proportionate, and that was the question in Zalewska. We accept you can have a workers' registration scheme. Is it proportionate to ask somebody to re-register every time they change employer, bearing in mind the serious impact of that on them? So, yes, once you appreciate that the Act and Treaty do confer rights and interests as a matter of EU law, then there is no reason for departing from Zalewska. Mr. Chamberlain says the reason for departing from Zalewska is later authorities in the shape of Vico Plus and Zalewsko. I say not. Vico Plus is at tab, volume 1, 2, tab 22, MS 1147. And the issue there was whether restrictions on Polish workers entering a labour market as there were restrictions on Polish workers entering a labour market under transitional provisions. No one suggested that there shouldn't be. The proportionality or the legality of those restrictions was taken as read by everyone in the litigation. The question was, did those provisions also apply to the supply of posted workers who were hired out in a third country? So the question that was asked, Mr. Chamberlain drew your attention to this, paragraph 18, was whether the analysis, whether there was a case for considering whether this was proportionate. This restriction was a proportionate restriction on free movement of services, but it was reframed because the question, was a restriction on free movement of services within the ambit of the transitional provisions. And what the Advocate General said was, once one accepts that this is really a case also about provision of workers, then the proportionality analysis should be done by reference to the transitional measures. So paragraph 24...
Sorry, we're in the judgment.
Yes, we're in the judgment. Sorry, no. I picked up the wrong volume. Wait a minute. Sorry, I picked up the wrong volume. It comes of working from paper copies. Yes, tab 22.
Would we have a page reference,
yes,
please, when you've got it?
Yes.
It's 1181, I think.
Sorry. Yes, the... Court, at paragraph 24, page 1181, starting in fact at the bottom of 1180, the referring court was unsure whether the maintenance of an obligation in respect of provision of services, insisting in making available of Polish workers in the territory of the Kingdom of the Netherlands, could be justified in the light of the derogation. And then they say, if national legislation is justified pursuant to one of the transitional measures, in this case, the measure provided for to that act, the question of the compatibility of that legislation with the services provisions can no longer arise. They weren't suggesting that proportionality review was ousted. They were saying that the question was to examine the legislation, its justification for the legislation under the transitional provisions and not under the free movement of services provisions. And having found then at paragraph 33...
I can see the force of your point in relation to the use of the word justified in paragraph 24. But in the next paragraph, we use the word covered by.
Covered by. And
Yes.
Mr. Chamberlain says that they are synonyms in this context.
Yes, and my submission, my Lord, is they are not synonyms. The reason is because once one says that in effect the supply of posted workers is the same as the supply of workers, then it falls within the transitional provisions, and no one is suggesting the transitional provisions on provision of workers per se are unjustified. And one sees that if one goes on to paragraph 33 on page 1183.
Paragraph 33.
30. Yes, paragraph 33 on 1183. Sorry, paragraph 32, they, having explained that workers are hired out, i.e. made available in the host state, it follows that the legislation of a member state, such as that in the main proceedings, must be considered to be a measure regulating access of Polish nationals to the labour market of the state. Consequently, paragraph 43, that legislation provided for the hiring out of Polish nationals in the terror state continues to be subject to the obtaining working permit, is compatible with the services provisions. It's because, in effect, what is being asked is, are the provisions which are ex hypothesi proportionate for workers Are those also applicable to the supply of workers through a service agency? Are those proportionate? The inevitable answer is yes, once you accept that limits on supplies of workers at all in that situation are justified.
I suppose you might say that if Mr. Chamberlain's fundamental proposition is right, that this authority sweeps away the application of the proportionality principle, it would have done so in rather more explicit terms.
Yes, yes. It's such a fundamental principle of EU law that one would expect to see it stated more overtly. While I'm in this authority, can I show you 3 other passages which are of assistance to other aspects of the case? One is paragraph 34, page 1183. They've said that the legislation, once it's a measure regulating access of workers to the labour market, therefore it is inevitably a proportionate restriction of right to provide services. Such a finding also necessarily follows from the purpose of that provision, which is intended to prevent, following the accession to the EU of new member states, disturbances to the labour markets due to the immediate arrival of large numbers of workers who are members of those new states. So that's what the transitional provisions are for. And then 6 lines from the bottom, the purpose is apparent from the relevant provisions of Annex 12, insofar as that paragraph provides the possibility for a member state, in case of serious disturbances of a labour market or threat thereof, to continue to apply the measures until the end of the 7-year period. So that has to be interpreted by reference to the purpose. And then, if I can just hop backwards briefly, 1160, this is the speech of the decision, opinion of the Advocate General, paragraph 46. The settled principle that transitional provisions as derogations from principles that provisions of EU law apply immediately and fully to new member states must be interpreted strictly. So that's relevant to the question that my Lord Sales was asking a moment ago. Fundamental principle that provisions of EU law apply immediately. And then paragraphs 47 and 48. Again, the scope of a derogation must be interpreted in the light of its purpose.
Could I say, I think it may be relevant to look at paragraphs 3 and 4 in the AGO, which is page 1150, because there the Advocate General seems to set out the structure that his opinion is going to follow. In paragraph 3, he says in his opinion, he proposes that the court focus its analysis on the interpretation of the transitional provision. And then at 4, he says, I shall maintain that in the light of its purpose in order to preserve its effectiveness, the transitional provision is to be interpreted as including within its scope the hiring out of manpower. It just struck me reading that the Advocate General, at any rate, seemed to be approaching it really as a matter of principle. Are hard-out workers within the scope or not? Rather than looking at the fine-graining analysis that one might expect if it was a proportionality review.
But because no one was suggesting it was disproportionate to have transitional restrictions on workers, one was saying, is this a workers' provision, in which case no one's suggesting it's disproportionate, or is it a services provision, in which case a separate proportionality analysis might apply?
Yes.
And he says, once you accept that these are not only units provided subject to a service, but people, workers working in that member state, then if limits on workers are proportionate, so are limits on the provision of those people qua elements of a service. Then the next case that Mr. Chamberlain relies on is the Levsko case, and that's on the previous tab, starts on 1101. It was about Slovenian cigarettes being imported into Austria during the transitional period at a stage where quantitative limits on imports from Slovenia to Austria could still be applied on a transitional basis, and at a stage when Slovenia was not required to raise its excise duty immediately to the generally applicable EU law levels. So the Austrian government generally allowed people to import 200 cigarettes when they came in from abroad on duty-free plane or whatever. But if you were bringing your cigarettes from Slovenia, they limited it to 25. And the question was whether that was keeping that higher quantitative limit or more stricter quantitative limit during the transitional period was necessary and proportionate. And it illustrates in my submission, before I come to the relevant passages, that as a matter of EU law, the scope of a power to derogate from free movement rights is specifically limited to what is necessary to combat the problem which was identified in the Act of Accession as the grounds for derogating. And in that case, the Court of Justice upheld the quantitative restriction on imports, but it's vital from this point of view that it did that using a proportionality analysis and asked itself the question whether the restriction on free movement of goods was proportionate to the risk of a significant loss of excise duty or tax evasion which it was aimed at. If I can make that good by reference to the judgment, at paragraph 42, MS 1137.
Is this in the judgment of the court?
This is the judgment, yes.
Thank you.
I'm sorry, what was the page reference?
1137.
1137.
Yes.
Thank you.
It's paragraph 42. The question arises whether prior to the Republic of Slovenia's accession to the Union, the national legislation at issue in the main proceedings establishing the reduced exemption of 25 cigarettes could be based on the limited powers available, and whether following the accession, the legislation can still, in view of the intervention of Article 24 of the Act of Accession, be based on those powers. Then paragraphs 54 57. The general nature of the wording implied that as regards the specific goods, a wide power was reserved to member states to reduce the quantity of goods concerned. It's true that a certain tension exists between that power and the general aim of the directive, which is to liberalise the system of taxes on imports in travel in order to facilitate such travel. In making use of that power, the member states are therefore required to limit, so far as is possible, the negative effects which the measures adopted could have on the realisation of the general aim, and thus strike a reasonable balance between that aim and the specific aim of the directive. That specific aim must take account of the particular nature of the goods in question and of the legal interest which the provision in question in the main proceedings allows to be protected. And then in paragraph 60, the specific risk, they explain the problem of short journeys in paragraph 59. In paragraph 60, the specific risk of evasion of fiscal policy and impairment of the objective of public health persists after the accession of the Republic of Slovenia, since the annex provides that new member states may, even though required to raise its rates gradually, postpone the application of the overall minimum excise duty on cigarettes until December 2007. It must also be observed that the scope of the measure in question in the main proceedings is specifically limited to what is necessary to combat such practices, which are regarded as posing, having regard particularly to their cumulative effects, a significant risk to the effectiveness of fiscal policy relating to tobacco products, and so on. Then they talk about the specific problems on the border, and in paragraph they explain why in paragraph 64 that's different from people bringing in cigarettes after air journeys, which are likely to be less frequent. And it is therefore evident, paragraph 65, that the limitation of the scope, the national measure at issue strikes a reasonable balance between the general aims and the specific aim of the directive. So there's a very close context analysis about why it's different from third countries, in paragraph 68 to 70. And it is in that context that at paragraph 74, page 1147, the court found that since the national legislation is justified in the light of one of the measures referred to in Article 24 of the Act of Accession, in this case the transitional measures, the question of compatibility of that legislation with other provisions of primary law can no longer arise. Once you accept it is proportionate to the aims for which the limitations, the transitional provisions and the Act of Accession are granted, then you no longer look at it through the prism of proportionality of infringement of other rights. But you do have to do a proportionality analysis. And you see that, perhaps you don't need to turn it up, you see that also in the opinion of the Advocate General in that case, where paragraphs 40 and 41, which are on page 1160, he looks at whether the differential treatment is proportionate to the purpose for which it's been imposed.
Sorry, what, I don't think 1160 is right.
Sorry, it's 1116. I'm sorry, my lord. So it's wrong to say that no rights of interests of A8 nationals arise during the transitional period, and it's clear in my submission that the court does have jurisdiction as a matter of EU law to consider the extent to which the discriminatory treatment of Latvian workers, by requiring them to continue to register under the workers' registration scheme and only to enjoy rights of non-discrimination after they've done that, is a proportionate restriction of the rights which they would otherwise enjoy as EU nationals and EU workers. Bearing in mind that different issues from the labour market may arise in different parts of the transition period for accession state nationals in comparison with EU nationals in general. That's the main submission I have on why proportionality analysis does arise, but because that was not a point that was raised in the Court of Appeal, we've gone on to make the submission that it's not a get-out-of-jail-free card, as it were, for the Secretary of State to say we don't need to analyse proportionality as a matter of EU law, because this would still be subject to EU law, proportionality analysis, a different kind of a proportionality analysis, I accept, through the prism of the Human Rights Act. We've summarised that in our written case, paragraphs 33 through to 40, MS 164 to 166. In short, state pension credit is a right which is within the ambit, the right of peaceful enjoyment of possessions under Article 1 of the First Protocol. It's not suggested otherwise. Article 14 of the European Convention on Human Rights requires a state to ensure equal enjoyment of the other rights and freedoms in the Convention without discrimination on grounds of any other status. And so, in my submission, if there is discrimination against A8 nationals in comparison with other EU law nationals in enjoyment of their rights under Article 1 of the First Protocol, because they don't get them unless they've signed the Workers' Register between 2009 and 2011, then there's a breach of Article 14 unless that discrimination is justified. And if that were the prism through which one was looking at the matter, then the question would be whether the 2009 decision to extend the Workers' Registration Scheme had the purpose or effect of treating accession state workers differently from analogously situated EU workers from non-accession states in the enjoyment of state pension credit, and therefore whether through that decision, that extension decision, the Secretary of State had failed without proportionate justification to secure equal enjoyment of the Article 1, Protocol 1 rights of those workers without discrimination on grounds of status. Mr. Chamberlain showed you a whole string of cases where it was said that where people were outside the EU national order, they were so intrinsically different that their circumstances were not properly and relevantly comparable. And I accept, of course, that if situations are so different that they are not comparable, then the question of justification will in effect speak for itself. But it does beg the question, which my Lord Sales put to Mr. Chamberlain, of whether one is saying the proportionality analysis doesn't arise at all, or whether one is saying that where people are subject to different legal orders, that is quite likely to be a a proportionate reason for distinguishing between them, given that the test for discrimination in the ambit of social security rights is whether the distinction is manifestly without reasonable foundation. And I say that it is the latter test, and that the Secretary of State cannot draw the comfort he seeks to draw from cases that distinguish between people who are outside the special legal order of the EU, third country nationals trying to get rights of one kind or another, and EU nationals who derive rights from national law, because that distinction on whether you're inside or outside a particular legal order is likely to be a relevant ground for distinction, and the proportionality analysis in such a case may well get tied up with the comparability analysis at all on a Carson-like compendious question basis. But that is not the same if you have a measure that is distinguishing between two groups of EU nationals, two groups of people within the EU legal order, as to the criteria they have to satisfy to enjoy a post-work benefit, the period of residence, the kind of residence, or how they acquire the period of residence to qualify for that benefit. And you
One way of looking at that is you have to have a relevant status
yes.
in order to enter the gateway to Article 14. And it's only when you've entered that gateway that you can seek to demonstrate or seek your opponent to require your opponent to demonstrate the proportionality of the discrimination.
And my Lord, I say the status is being a national of an accession state to the EU as opposed to being a national of a different state to the EU. And that question of status is not really a gateway, it's part of the compendious question of whether these situations are sufficiently similar to require comprehension and justification. So
Well, gateway is probably the wrong expression, but it's a prerequisite to the Article 14 relief.
Yes, but my Lord, the way you put it in Brewster is that Article 14 requires the state to secure equal enjoyment of the other underlying convention rights without discrimination on grounds of status. What is discrimination on grounds of status will depend on whether the status is a rational and relevant difference of situation, such as to, in itself, intrinsically, justify the difference of treatment of two people or not.
So what is the similar situation as between the A8 member and the pre-existing EU member that you're founding on?
It's being an EU national working in the United Kingdom for a period after 2009 to 2012. And for those people, if you're an EU national not from an accession state, the whole of that period of work would count as residence in the enjoyment of an EU law right, which would justify you getting a state pension credit. And if you're an EU law national, a citizen of the EU but from an A8 state who has failed to sign the register, that's the special additional criterion, then you can't get state pension credit. If you signed the register, you could. So that's the separate barrier. What is the justification for having that separate barrier or excluding people from the right to state pension credit because of their failure to sign that register? Mr. Chamberlain says, well, that's just somebody who's outside the legal order because they didn't sign the register. They didn't become, on profeta basis, they didn't become a member of the EU legal order. But I say that begs the question of why they didn't become part of the EU order. It's the discriminatory criterion that prevented them from becoming part of that part of the legal order. Mr. Chamberlain also referred you to the decision of this court and I'm going to forget the pronunciation of the case, Noasley, that's right. And he made reference to the reference in that case, paragraph 47. This is MS1, it's 1331, MS1433, to Ponomariov. And the reference in Ponomariov, you needn't turn to it because I'm going to take you to Ponomariov itself, but in Noasley, this House used Ponomariov as authority for the suggestion that if people were outside a legal order, that could in and of itself, constitute a justification for excluding them from the benefits of that legal order. That is what was said in Ponomariov, but it was said in part of an analysis as to whether, of proportionality of excluding a particular group from that legal order. In A22, tab 57 is the Ponomaryov case. Starts at 2059.
I'm so sorry, I missed the reference.
Are you in the paper? 22, tab 57, starts at 2059, my lord.
Thank you.
That's the education in Bulgaria
It
case.
is.
Isn't it?
They were technically Russian nationals, or they'd lived in Bulgaria for years with their mother, who had married a Bulgarian national, and had failed to renew their residence permits in time. And that was what made them required to pay fees for their secondary education, which they would not have been required to pay if they had been Russian nationals or if they had obtained the certificate in time. And at paragraph 50, 2071, paragraphs 48 and 49, 2070, they decided this fell within the ambit of the right to enjoy education. And so then the question on Article 14, starting at 2071, was whether there was a difference in treatment between the applicants and others placed in an analogous situation. So the comparability question my Lord Kerr was putting to me. And it was said in paragraph 50 that the applicants' secondary school students were, unlike others in their position, required to pay school fees. This was due exclusively to their nationality and immigration status. And at the bottom of that paragraph, the applicants were thus clearly treated less favourably than others in a relevantly similar situation on account of a personal characteristic, i.e. nationality and immigration status. Then the question of whether the difference in treatment had an objective and reasonable justification. And at paragraph said there's a margin of appreciation. Paragraph 54, page 2072, the last 5 lines of that are the bit that were quoted in the Noazi case. For instance, the preferential treatment of nationals of member states of the EU may be said to be based on objective and reasonable justification because the Union forms a special legal order which has, moreover, established its own citizenship. And then in paragraph 59, in assessing the proportionality, the court does not need, in the very specific circumstances of this case, to determine whether the Bulgarian state is entitled to deprive all unlawfully residing aliens of education benefits, because, end of paragraph, it's just looking at the applicant's personal situation, noting that they were not in the position of individuals arriving in the country unlawfully and then laying claim to use of public services. They were somewhat inadvertently in the situation of aliens lacking permanent residence permits. The authorities had no substantive objection to their remaining in Bulgaria and apparently never had any serious intention of deporting them. Thus, any considerations relating to the need to stem or reverse the flow of illegal immigration clearly did not apply in this case. And then paragraph 62, the authorities have not taken that into account. So the fact that these are people who may or may not fall outside the EU legal order does not mean that the proportionality analysis would simply not arise under Article 14. It is a factor which would doubtless be taken into account in that analysis. But even if it were taken into account, bearing in mind that these are members of the EU legal order who somewhat inadvertently, as a result of failing to sign the workers' register, which they were fully entitled to sign and could have signed earlier on, have lost a very valuable right to state pension credit. The question is whether the requirement that they sign the register is a proportionate infringement of their property rights, of limiting their property rights when they are not so limited for all other members of the EU national order, and on a Ponomaryov type basis, where people such as the respondent in this case had not entered the country unlawfully, were not going to be deported, and so on. My submission is no. Mr. Chamberlain's final point is, of course, it's right that the analysis would go through a slightly different legal prism. It would go through the Bank-Melat test for proportionality, and the court's role would be to decide whether the restriction was manifestly without reasonable foundation. But in my submission, this is a case a bit like FAM, where even though the analysis is different, it may reach the same result. I invite you to note that the upper tribunal found, at paragraph 118, MS 273 in the core bundle, that if the manifestly inappropriate test in EU law were to apply, the extension regulations would, in my view, fail it for all the reasons that the upper tribunal judge had given for finding that the justification was so singularly unconvincing. And in my submission, therefore, if it was said, is this restriction on access to state pension credit manifestly without reasonable foundation, the answer would also be, obviously, yes, it is. The real question for this court is the level of scrutiny which is appropriate, given how nuanced and fact-sensitive the application of the test is. And the appellant's appeal on that is based on a complaint that the upper tribunal took the proportionality decision for itself, which the appellant says is an error of approach. They say that in their written case at 42.1, 42.2. I'm going to have to stop now as it's the end of the day, but the important point is that it is simply wrong to say that it's an error of approach for this court to, or for the upper tribunal rather, to have decided the proportionality question for itself. I will take you tomorrow to some of the passages of Lumsden, but can I leave you tonight with the point that the criticism made by Mr. Chamberlain was that the upper tribunal was engaged in striking the balance for itself rather than considering whether the balance struck by the Secretary of State was properly open to him. That was the correct approach. You see that from paragraph 101 of Lumsden, MS A1329, MS 1393 to 1394. And that was where the Supreme Court in Lumsden criticised the approach of the Court of Appeal in Sinclair Collis to the contrary. It is a question for this court. Of course, this court will give some deference to the analysis of the Secretary of State as primary decision maker if it has any evidence as to that. But in this case, the court has no evidence from the Secretary of State as to what analysis of proportionality and balancing he undertook for himself, because the Secretary of State didn't put in any evidence. It just referred to the MAC report, which was considering what was sensible, by reference only to the point of view of the impact on the labour market and not from the point of view of proportionality.
Thank you. Well, we'll adjourn now and look forward to hearing from you further tomorrow morning.